Thank you, Your Honor. May it please this honorable court, members of the jury, and counsel. Over the past couple weeks, plaintiff's counsel has shown you a lot of things. They have shown you articles, pictures, memos, emails, tweets, screenshots, charts, and graphs. Some of those things they have shown you over and over. But none of those things is the basis for this lawsuit. They have shown you Mr. Delario's commentary about the Hulk Hogan sex tape. They even had Mr. Denton read parts of it. But the commentary is not the basis for this lawsuit. Nevertheless, Mr. Turkel, with great passion, refers to it here as that disgusting, disgusting thing Mr. Delario wrote. Mr. Balea told you that early in the trial. He said, I never had a problem with the article. His lawyer, Mr. Houston, for his part, he told you the same thing the next day. He never had a problem. They were never upset about the article. They both told you it was the video excerpts. Mr. Balea is suing on the video excerpts. And sure enough, plaintiff's counsel has shown you video, a lot of video. They have shown you video of interviews with Mr. Denton. They have shown you video clips of depositions. They have shown you video clips of the plaintiff being interviewed by Showbiz Tonight, by TMZ, and by Howard Stern. But what video did they not show you? The very one that Mr. Balea claims was so bad, the one that was so devastating, the one that was so damaging, the one that he is suing on. Now ask yourself, why did they not show you that video? The video that is the reason we are all here. Because that video does not show all that much. The video Gawker posted is not like a real celebrity sex tape. It's not like Kim Kardashian. It's not in color. You don't see close-ups of body parts. You don't see graphic sex acts in vivid detail. Here, 9 seconds of sexual activity. Dark, grainy video, that's it. He has avoided showing you the one piece of evidence that is critical to his case. I say to you, members of this jury, when you retire to deliberate, please watch the video excerpt. The video excerpt has been entered in evidence as Defendant's Exhibit 310. Watch it, decide for yourself, make your own judgment. Ask yourself, do you think anyone is going to pay $5 for a view of that? 9 seconds of sex. $5? You decide. Now, let's talk a little bit about the commentary. Gawker received a 30-minute DVD. Mr. Delario decided to write a commentary about the Hulk Hogan sex tape story. It was already in the news, and we'll come back to that. He wanted to write about America's fascination with celebrity sex tapes and what the latest sex tape said about this celebrity sex tape phenomenon. When Mr. Delario decided to use excerpts from the DVD to accompany his commentary, he gave instructions to the folks he worked with, told them to edit this video down. The first version they came back with was 3 minutes. He asked for it to be edited further, cut this down more. Video that was ultimately posted was 1 minute and 41 seconds. As I said to you a moment ago, it contained 9 seconds of sexual activity. Make no mistake, let us be clear, Mr. Delario wanted to show some sexual activity. This didn't come in by accident. He wanted to show it a little bit, a little sliver. But his focus in this piece, this commentary, was on the unglamorous aspects on the video. The ordinary conversation between Mr. Balea and Ms. Clem. Instead of focusing on sex, the video highlighted what Mr. Balea had for dinner, Mrs. Clem joking that he was a hot commodity. Mr. Delario used the video excerpts along with his commentary. He used the video to make a broader point about sex tapes in our modern American culture. If what he wanted to do was make a salacious sex tape of Mr. Hogan, the so-called highlight reel of sex, you can bet your bottom dollar that what Gawker published would be dramatically different than what it published. Now, let's talk about this key issue. One of the central issues is this business about public concern. Judge Campbell has instructed you that in deciding whether the video relates to a matter of public concern, you need to consider not just the video itself. You need to consider its context. Context is key. As we will see, there are several parts to this context. First, let's focus on Mr. Delario's written commentary which accompanied that video excerpt. Read it for yourself. Read the commentary, start to finish. Read the whole thing. Remember that although it's part of the context for the video, as I told you at the outset, Mr. Balea is not suing over the commentary. Now, we looked at the commentary itself is Plaintiff's Exhibit 2, that is the October 4, 2012 post. We looked at its text a little bit. You saw that it commented on and poked fun at this public fascination with celebrity sex. It was honest about wanting to watch the tape and being embarrassed about watching at the very same time. There's tension there. These are feelings that many felt, and Mr. Delario tried to capture that in a humorous way. Mr. Delario explained that Hulk Hogan was a figure from his childhood. He watched his matches, even had wrestling toys. Remember that? He said he had these little thumb wrestlers. Mr. Delario remembered Hulk Hogan as the all-American hero, an iconic figure. Mr. Delario explained how it was both amusing and strange that a childhood good guy, an American icon, was having sex with the wife of his best friend, Bubba the Love Sponge. Mr. Delario explained to you how odd it was, at least to him, Mr. Delario, that Bubba blessed this and was even in the room when his wife and his best friend were engaging in a sex act. Finally, Mr. Delario's commentary explores the realization that celebrity sex, at the end of the day, is rather ordinary. He describes awkward moments and describes the sex he watched. Now, while Mr. Balea claims that the video crossed the line, I say to you, see for yourself whether the video content is meaningfully different from the things that Mr. Balea said is okay, which is the commentary. Look at that, make your own decision, make your own judgment. Now, we've talked about one part of this context for the video, which is the written commentary. Let's shift our focus a bit to the larger context, the public discussion that was already going on about this Hulk Hogan sex tape. Now, we could, just to, hopefully this will be a help of assistance to you to kind of track the chronology. All right? You've heard evidence about how news of the Hulk Hogan sex tape was first reported by TMZ in March of 2012, 7 months before Gawker published the post. You've heard that Mr. Balea and Mr. Houston were quick to appear on TMZ. Mr. Balea joked that he didn't know who the woman was because he had slept with so many brunettes during that time. He joked about a thong-shaped tan line, all right, visible on the sex tape. For his part, Mr. Houston, he joked that they were happy that at least the sex tape was not with a guy. Mr. Houston testified, sat in that stand, told you folks that they were sending a message to persons who had the tape that they would take any violation of Mr. Belea's rights very seriously. But who among us thinks it's a good idea to send a serious message through TMZ and send that message through jokes and banter? TMZ is the place that a celebrity goes to get even more attention for a sex tape. Now, if we could look at the second slide, please. Okay. Now you see April the 19th and the 23rd, again, of 2012. You've heard evidence that still photographs from the Hulk Hogan sex tape were published by The Dirty online, and that was 6 months before Mr. Delario published his commentary. Mr. Houston tells you that, well, we sent them a cease and desist letter. But those sex tapes were still up when Mr. Delario posted his commentary. You ask yourself, well, how do I know that? How do I know that's the case? You know that because you remember the other day when we went through those links, those little red portions, okay? Those were working links, and if you clicked on them at the time, it would take you to this piece that appeared in The Dirty. This news that stills were surfacing from a Hulk Hogan sex tape, was covered far and wide. Now, look, please, if you have any doubts about this, we've introduced Defendant's Exhibit 829, which is this document here. And what it was intended to do is kind of provide for your convenience what I would describe as one-stop shopping. If you want to see the run of coverage starting from March 7, 2012, up, moving forward in time, up through the point that they did the Gawker post in October, you can look here. And you'll see a wide range of stories reporting on this whole sex tape business. You will see that the coverage was sustained and the coverage was wide-ranging. It ranged from celebrity sites like VH1 and Access and E! Online to sports sites, all right? Wrestling sites, sites like the Bleacher Report, to mainstream news. You'll see in there stories on this Hulk Hogan sex tape in outlets like the International Business Times and TodayShow.com. So this is out there. This is being picked up widely. You heard Mr. Houston testify that he was fielding daily calls from the media during portions of this period. Now, through all of this prior news coverage, you have heard the story evolve. It started out that the details about the Hulk Hogan sex tape were fuzzy. You had Mr. Hogan claiming he didn't know who his partner was. You had that. All right. And then when the photographs, remember back in April when these photographs start coming out, they were not by any means the clearest, people started, scratching their heads saying, well, what is the deal here? Where did this happen? People were interested. So they start to figure out, or some people, they start to figure out that geez, this looks like it's in Bubba the Love Sponge's home. Then the National Enquirer comes out on May 21st, and they publish a report saying that what this was all about is that Bubba put these cameras in there to try to catch his wife in a sex act with Mr. Belea. And Mr. Delario's post comes along, and it says, no, There's visual proof. 1, the tape existed. 2, the woman was indeed Heather Clem. 3, Bubba Clem knew. It wasn't about trying to catch her. He knew this. And 4, he was even present during some of this sexual activity. All that prior coverage is part of the broader context for the challenge video that's at issue in this case. So we've looked at the context that you had there on the post. We've looked at the broader context, which is this prior coverage. Now, I want you to shift your focus again and look at the third part of this context analysis. You say, well, what's that? What's the third part? The third part is Hulk Hogan himself. He has made choices in his life. He has chosen to seek the spotlight. He's not just a wrestler, not just as a movie actor, not just as a spokesperson for all manner of products, and not just as a reality TV star. He has consistently chosen to put his private life out there, front and center. Again and again, he went on Bubba and Howard Stern's radio programs, and he talks in graphic detail about his sex life and things like how big his penis is. He's talked about his affair with Christiane Plante in his second book. That was the young woman that was a friend of his daughter. He discusses their sexual encounters, has no, seemingly at least, no difficulty sharing that with folks. In fact, he said he thought readers would find that book interesting. Now, he tells you, he comes here and tells you folks that, well, this was the Hulk Hogan character, like an actor playing a character in a movie. But think for yourselves. Apply your common judgment. You know that that's not right. An actor playing a character in a movie does that on the set. But when they go on a talk show, they're themselves. When he went on Bubba's radio program to talk about how large his penis was, he did it to promote his real-life daughter Brooke's recording career. You may remember that from hearing that clip. And when he went on Howard Stern and allowed Stern to talk about his family's sex life, that too was to promote their careers. Remember, he was doing the Hogan Knows Best thing at the time. Brought them all on. Mom, kids, the whole Hogan clan went on there and talked about sexual matters. But even if you credit the notion that Mr. Balea and Mr. Hogan are two different people, the fact is, the rest of us can't tell them apart. So when Mr. Delario wrote his post, you will not see any mention of Terry Balea. All you see are references to Hulk Hogan. Since plaintiff admits that Hulk Hogan has made his sex life incredibly public, his claim that Mr. Delario was supposed to treat him as Terry Balea, ordinary Joe, guy next door, makes no sense. Mr. Balea told you that Hulk Hogan has no right to privacy. Well, that's the fellow that Mr. Delario thought he was writing about. But he comes to court and he tells you folks that when he is Terry Balea and when he is Hulk Hogan, when in truth it seems that at times he can't. He doesn't seem to know which is Terry, Hulk. Now, this prior discussion of the tape and Hulk Hogan's prior graphic discussions of his sex life, his genitals, and all of that is a crucial part of the context, right? Because it goes to the heart of what this case is about, what the First Amendment is all about. Long before Mr. Delario comes to this story, lots of people are out there talking about these things. See for yourself, there's been a host of news reports. Mr. Balea, for his part, he's out there with Mr. Houston talking and joking about it. But what they do is they seek to punish Mr. Delario for adding his voice to the others that were already speaking about the Hulk Hogan sex tape. A chorus of voices in which Hulk Hogan is often the loudest. A key aspect of this public concern doctrine is that things that people are already talking about are fair game and should not be the stuff of lawsuits like this to squelch that speech. As Judge Campbell has instructed you, a matter of public concern is anything that relates to any matter of political, social, or other concern to the community that is subject to general interest and concern to the public. The judge's instructions go on to explain the mere fact that a publication contains arguably inappropriate content does not remove it from the realm of legitimate public interest. Here is where the rubber meets the road. Mr. Balea, his counsel wants you to approach this simply, just to make it seem very simple. He argues that because the tape depicts private sexual activity, it can and should be punished. But you took an oath. You folks took an oath to follow the law and to avoid being guided by passion, sympathy, or prejudice. In this country, it has long been clear that where a person joins in an ongoing conversation, even one about sex, that speech is protected. Otherwise, we will become a nation where powerful celebrities, politicians, and public figures will use our courts to punish people for saying things that they frankly do not like. And we will all be worse off as a result. Here, Mr. Balea's lawyer argues that this post and the video were not providing information to the public, but were instead the sensational prying into private lives for its own sake. You saw that in what we just looked at. Now, he gets into this whole thing about this prying business. They talk about Mr. Delario admitting that the Hulk Hogan penis part was not newsworthy. They try to pick these apart, little pieces. So they ask him if he thought the Hulk Hogan's penis is newsworthy. Mr. Delario answered truthfully, no, he didn't. When you subject that answer to scrutiny, think about it, that answer makes sense. Mr. Delario does not believe for one moment that if he just went through that whole video and got a screen grab of Mr. Balea's penis and put that on the internet, that would automatically be newsworthy. But that's not this case. The proper question here is whether the video that they created, the one they posted, along with the commentary, is that newsworthy? He was also asked about whether this was a morbid and sensational prying into people's lives for its own sake. But again, that isn't a question you ask a lay witness. It is a legal standard. It's in the instructions. And Mr. Delario is many, many things. But the one thing he's not is a lawyer. And he answered no. He has said time and again that the post, including the video excerpts, what he selected and put up, that is newsworthy. All right? Now, one other thing before we move off of this. Mr. Balea's counsel has also argued that Mr. Delario did not know about Mr. Balea's prior discussions of his sex life. But that is not the point, all right? The legal question you're asked to decide is whether the subject matter relates to a matter of public concern. The legal test is not what Mr. Delario knew, nor is the legal test what did he choose to include in the post. We saw the other day that the 2 points along this road we just looked at that he chose to include was a link to the March 7 TMZ report, which started this whole thing, and he linked to the piece about the stills when they came up. He doesn't have to. The law does not require that he become an expert in the Hulk Hogan sex tape controversy. He doesn't have to have every one of these articles. That's not the analysis, all right? And that makes sense. The test is designed to protect subjects that are out there being discussed by news media, by our citizens, things that folks are interested in. It does not require that a person participating in the discussion know everything about it or reference every one of those pieces in their story. It's not the way it works. It's not the way it's ever worked. Now, one last thing on, excuse me, Mr. Delario, this business about the post. As I said to you a few moments ago, he didn't just post a 30-minute sex tape, unedited and without commentary. He didn't even post a 1 minute, 41 seconds full of sex, right, without commentary. Instead, he posted 9 seconds of blurry sexual activity from a 30-minute sex tape. 9 seconds. The rest of that 1 minute and 41 second tape shows conversation that directly complemented his commentary, making the point of the ordinariness of celebrity sex tapes. That is not that's not the sensational prying that would remove it from the realm of protected speech related to a matter of public concern. Once again, this was a subject of general interest, with millions of people interested in it, following it, reading these articles. TMZ sends out press releases. Now, the fact that some of us, we may not care for its content. It's not our cup of tea, right? It's not something we're interested in. But that does not change the legal rule. Let's be honest. A big reason that there was significant interest to the public was how this situation, how it came about. Fueling speculation as to why Bubba was allowing Hulk Hogan to sleep with his wife, and why was there a tape out there? This kind of thing, I don't know, some folks have some interest in it. They're going to follow that story, and indeed, they did. Now, let us shift our focus a bit and talk about Mr. Belea's claim that Gawker's publication caused him severe emotional distress. A.J. Delario and Emma Carmichael, who worked on the story, both testified when deciding whether to write and publish about the Hulk Hogan sex tape, they were not focused on Mr. Belea's feelings. Again, make no mistake about it. That's clear. Nick Denton, who was not involved in writing or editing the story, said for his part he would have felt the same way. I know from our voir dire process that none of you work in the field of journalism. And I can see where you look at that, you look at what these folks have said, and you say, well, I got to tell you, that sounds harsh to me, okay? But it is what journalists do, and I would say to you, at the end of the day, it is what we want journalists to do. Think about it. When Gawker reported that Rob Ford, mayor of Toronto, had been videotaped smoking crack cocaine, let's not kid ourselves. Mr. Ford was undoubtedly upset, very upset. But as journalists, they can't take that into account. And the same is true for other kinds of journalism. A restaurant critic simply cannot review a restaurant honestly if he's worried that the chef may lose his job? All the wait staff may be out on the street looking for a new position. It's tough. Journalism is a tough job. And over the long run of our history, it is a good thing when journalists are free to write about public figures without worrying about whether those public figures are going to be happy about how they're portrayed. Mr. Boulay has said so himself. He told us from the stand, when you're a celebrity, you have to take the good with the bad, right? And part of that is that people get to write about you without the same sensitivity we expect when you write about ordinary folks. It goes with the territory that Mr. Boulay, if anyone knows, he knows that. So let's talk about his actual feelings. Mr. Boulay testified, never watched the video, all right? Never watched the video he's here suing us about. But when he was on his media tour, he talked about having seen the video. He even told a dramatic story on the Howard Stern show, which Mr. Boulay's lawyers played for you. That was one of the clips you saw last week. And he told the viewers of the Howard Stern show, he said he watched about 15 seconds of it, and it got sick to his stomach. All right? But that was not true. He testified it was not true. He just said that Howard Stern's listeners, saying that to Howard Stern's listeners, doesn't count as a lie. Why? Because it was Hulk Hogan, it was not Terry Boulay. Okay, think about that. The same day, he gave another interview, this one on the TV show VH1. On that show, he tells these folks, he says he's seen the whole video clip that appeared on Gawker. When I played those video clips, I asked him, were you being truthful when you were on TV? And he said no. He didn't have any explanation for why he would not be truthful. He just claimed, quote, I was probably in the Hulk Hogan mode. So I asked him, so when you are in Hulk Hogan mode, rules, things like telling the truth, do not apply? And you recall he said yes. He said, whenever I leave the house, I'm not Terry Boulay, I'm Hulk Hogan. And whenever he's outside the house, whenever he's Hulk Hogan has, quote, artistic liberty, is how he described it to you folks. Artistic liberty. Judge Campbell told you what constitutes severe emotional distress. As she instructed you, emotional distress is severe when it is of such intensity and duration that no ordinary person should be expected to endure it. Now, what do we know about Mr. Hogan's real feelings? Let's put together the whole chronology. Starting in 2007, when the sex tape was recorded, that's when he experienced what he described to you as an all-time low. He testified that he was so low, that he finally succumbed to the wiles of Heather Cole. Okay, but as it turned out, he succumbed 3 or 4 times. He also testified that he still hasn't really recovered from that part of his life. So that's where he starts from. 5 years before Gawker publishes anything, he's at this all-time low back in 2006, 2007. Then in March 2012, when Gawker first reports about the Hulk Hogan sex tape, he jokes about it on the TMZ show. Now ask yourself, he goes on TMZ, takes his lawyer along with him, jokes about this, but he doesn't sue TMZ or demand that they destroy. They say on that, you can look at it for yourself, I urge you to. They say that they've seen the sex tape. They got it. But he doesn't whip out the cease and desist letter, doesn't sick his lawyers on them. No, sir, no, sir. Doesn't demand that they destroy that footage they have. No, he goes on the show and jokes with those folks. Now, move forward. April 2012, the Dirty posts pictures from the sex tape. Mr. Houston, for his part, he sends Joe Francis of Girls Gone Wild fame to try to persuade the Dirty to stop. That didn't go anywhere. They don't stop. So now, Mr. Galea testifies, well, he, quote, didn't have a problem with the Dirty publishing those stills. Well, I thought this was supposed to be devastating. This is the worst thing in the world, naked pictures out there of you from a sex tape. But he didn't have a problem. They were out there. Okay, fine. Then on October 4 of 2012, Gawker publishes its post. Right? Mr. Houston sends a cease and desist letter to Gawker the next day. What does Mr. Galea do? He doesn't race into court. This is the end of the world. We're going to run in there and get an injunction. No, sir. What he does is, they're waiting for a response, and what he does is he goes on a national media tour. You heard Jules Workman, that TNA publicist. She advises him, listen, don't talk about the sex tape. She advised him to acknowledge it. Thank you. So where we were is this PR person advised him, he goes on these shows fine and dandy, but here's what you should do. She says, say it's been a tough week. It's been a tough week, I grant you that, and immediately pivot to promoting wrestling, which was supposed to be the whole point of the tour. But he did not take her advice. No. You saw that for yourself last week, right? He goes on Howard Stern and other high-profile shows, and he talks about the sex tape. Not like he was advised. He talks about the sex tape at length. And then he adds a previously unplanned appearance on TMZ about the sex tape, an appearance that the publicist told us wasn't even on the tour. He fits this way. Again, TMZ. And that, he testifies, is when he learned that Bubba was the one who recorded him. According to Mr. Balea, before that, he believed that the culprit was Heather Clem, the woman whose videotape deposition you folks saw on Wednesday. It was about that October TMZ interview that you heard his most vivid testimony about his supposed emotional distress. He testified that when he heard news about Bubba's betrayal, his hands started shaking violently, couldn't quit shaking, testified he felt like he was having a heart attack. It wasn't when he learned that Gawker had published excerpts from the sex tape. It was when he learned that Bubba was the one that recorded him. That afternoon, he got a response from Gawker, a response that made clear that Gawker intended to stand on its First Amendment rights. Gawker made clear the video would not come down. And Gawker's counsel, you'll see that in the record. You want to see what Gawker's position was on this matter, what it thought its legal rights were? It's right there. Its counsel explained to Mr. Houston as clear as day that its posting under the law was lawful and it was legal. For his part, what did Mr. Balea do? He continued to talk to the press. You saw him appear, that's our chronology there, you saw him appear on Sway's show the next morning as part of his media tour. Now, you heard him tell Sway that finding out about Bubba was, quote, probably the toughest and most traumatic thing he'd ever experienced. And it just turned my world upside down more than anything ever has. You heard the testimony of Heather Clem. She said, what'd she say? She said, if you are really upset about something, you don't go talking about it in the media. She said, what'd she do? She stayed silent. He did not. And she could not, for the life of her, understand why. Then, on October 15, the Gawker story had been up on the internet for 12 days. Mr. Balea went to court. But he doesn't go to court quietly, hoping to put all this behind him. Instead, he has his attorneys. Remember we showed you that clip from a local press report? He has his attorneys call this big press conference on the courthouse steps. And you heard from his publicist that that press conference was timed to coincide with the 5 p.m. news. Get maximum exposure. His publicist, for her part, you saw Ms. Trout, that's his publicist, she made sure that the gossip in the tabloid press knew about the lawsuit. Who'd she send her releases to? TMZ, Us Weekly, E! Entertainment. Not the New York Times, not the Tampa Tribune, no. Mr. Balea testified that, for his part, he was somewhat disappointed, surprised that there weren't as many cameras as there were for the OJ trial. Ask yourself, does this sound like severe emotional distress? What did he say about his emotional distress, at least when he wasn't in character? He admitted, didn't seek any medical treatment. He did not see a therapist, did not see a counselor. He told us he lost sleep, lost appetite. That was it, right? Some sleep, some loss of appetite. Now, we do have the TNA publicist who said she saw him tear up talking to Kathy Lee Gifford, Hulk Hogan and Kathy Lee Gifford on the Today Show. And that's it. That's it. That's his severe emotional distress. That is all he has to show you. Finally, when you think about Mr. Balayo's emotional distress, you need to consider that he does not live a life like ordinary folks. This is a man who has used publicity, and he's used to public attention. Also a man who is quite comfortable discussing the intimate details of his sex life in public. You saw that, right? You saw that repeatedly. We know he is not upset by that kind of exposure because he voluntarily exposes himself to the world. Remember the Hogan Knows Best thing we looked at briefly? He's sitting there on a toilet. I don't know about you, but there he is on the airwaves, goes on Bubba's show. Great. He says, after the post, he was so upset. But then again, ask yourself, look at how he behaves. Look at the choices he makes. He says he was upset about that Gawker post, and yet made the choice to appear in a tea bag on a wrecking ball, basically a parody of the Miley Cyrus video. He talked about that. In that video, she's completely nude. He has a very different baseline for privacy than you or me, and that needs to be taken into account. Now, as Judge Campbell instructed, to prevail on his claim for publication of private facts, you must find that the facts were actually private. This he has not done. This he cannot do. On this, the evidence is overwhelming. Mr. Delario revealed nothing that plaintiff has not already put in the public domain by his own words, his own actions, and his own choice. His extramarital affairs, his sexual prowess, his sexual liaisons with Christiane Pont and other, quote, unnamed brunettes. The fact that he had been taped in bed with a woman who many surmised was Heather Clem, that was out there. His business about the size of his penis. If you think about it, if you stop and think about this record, you would be hard-pressed to think of anyone other than an actual porn star who had made the attributes of his body parts and his prolific sex life more a part of our public discourse. And he's done so on television, on radio, in print. And that is why he cannot establish that Gawker's publication was highly offensive to him. It's not whether it's highly offensive to your neighbor who conducts himself in a very private way, him. Because as is plain by all he had said and done with Heather, with Bubba, with his daughter's close friend, the plaintiff is not an ordinary man with ordinary sensibilities. Plaintiff has failed to carry his burden of proof on these essential elements of the claim. Now, he has told you that he had a reasonable expectation of privacy. Remember when we started in voir dire and you were asked these questions about, well, does a person have a reasonable expectation of privacy in their own home? Folks are like, yeah, that makes all kinds of sense. He wasn't in his own home. Where was he? He was in the bedroom of his best friend. Now, let's think that through. But his best friend is who? Bubba the Love Sponge. And he was in Bubba's house. He was in Bubba's bedroom. And when Mr. Balayo was in Bubba's bedroom, about to have sex with Bubba's wife, what was the one question? The one question Mr. Balayo asked. He asked his best friend Bubba, "You're not filming this, are you? You're not filming this, are you? Let me ask you something. Who asks that? And why does he ask that? Why ask that question? Because it is Bubba. Because it's Bubba's bedroom. If anyone If anyone knows the dark and twisted things that Bubba is into, you can bet it is Mr. Balea. You can bet it is Hulk Hogan. Mr. Balea, Mr. Hogan, knows Bubba better than anyone. He knows that Bubba shares his wife with other people. He knows there's there's cameras in Bubba's house. He knows about the camera in Bubba's bedroom. Do you have any doubt? If you want the truth, listen closely to Heather Clem. She told you she did not want to have sex with Mr. Balea. She told you that Bubba asked, and she said yes. Bubba chose who he wanted her to have sex with, and he directed her to have sex with Mr. Balea, even though she had little relationship with Mr. Balea. In fact, you saw the testimony. Mr. Balea testified that he didn't really socialize with her. He didn't talk with her on the phone. He only visited the Clem's house a couple times. Mrs. Clem complied time and again. In Mr. Balea's house, at the radio station, at a hotel in Tennessee, and in Bubba's bedroom. Mrs. Clem never discussed these encounters with Mr. Balea. They were arranged between Bubba and Mr. Balea. So what did Mr. Balea do for his part? What did he do? On national TV, on syndicated radio, he told Howard Stern and others that Mrs. Clem came on to him. How she would grab the phone. How she said she wanted to see his thing and do this and that and the other thing. How she wanted to F him. Saying this on national broadcast. How she was relentless. Relentless. The truth, Mrs. Clem told you the truth. Bubba and Mr. Balea made the arrangements. She did what she was asked by her husband, Bubba. For Mr. Balea's part, we will never know the truth. Now, let's look at his book. Do you remember we introduced his book? This is actually his second autobiography. This is the book. It's Hulk Hogan, My Life Outside the Ring. If you care to look at it later, it is Defendant's Exhibit 68. And if we look at the first page, in the acknowledgments, the third paragraph, what you will see is the following. Quote, "And of course, the man who will take our antics to the grave and who's always there, no matter how heavy it gets, Bubba the Love Sponge." Now, antics, I take it, that they will both take to the grave. Ask yourselves, is this just another antic between two best friends? Another secret that they'll take to their graves? As Hulk Hogan the wrestler might say, is this all a work? Remember that testimony? I asked him, what's a work? And he explains, a work is a carefully choreographed dance between two persons working together. Again, look at what Heather Clem told you. After she heard that David was considering going to the authorities, she offered to help. But she never heard from Mr. Houston. That left her concerned. She told you she does not know whether Bubba released the tape. She told you she does not know whether Mr. Balea released the tape. And she told you that she doesn't know whether this is a publicity stunt. That testimony the other day from Ms. Clem got a little garbled, so I'd like to give you an opportunity to just see that again. Let's take a look at that.
Did you ever think that this whole situation was a stunt by Mr. Clem?
I don't know.
Did you ever think that it was a stunt by Mr. Balea?
I don't know.
And you don't know one way or another whether either of them were involved in the release and distribution of the tape?
I do not know.
Mrs. Clem doesn't know whether this is a publicity stunt. What she did, pardon me. So ask yourself, what does she know? What does she know? She knows that she, for her part, was not out there talking to the press about the sex tape. She knows that one person was. Mr. Balea was talking to the media, and he would not stop. She knew that Mr. Balea wanted publicity. Was it a publicity stunt? The exact thought crossed Mr. Delario's mind. This had all the ingredients of yet another classic celebrity sex tape scandal. A celebrity who claimed, in quotes, he was secretly filmed. A celebrity who lawyered up. A celebrity who went on TMZ and talked about the sex tape. A sex tape that he claimed he didn't want circulated. Mr. Delario noted that in his commentary. The Hulk Hogan sex tape followed the same familiar pattern of other celebrities who had worked a sex tape scandal. Was it a publicity stunt? Ms. Clem, isn't sure. Mr. Delario thought it looked that way. Now, only two people know for certain, Bubba the Love Sponge and Mr. Balea. But you will not hear from Bubba. Look at the facts. Look at Mr. Balea's response. Look what he did when the news of this sex tape first broke, and look where he goes when he knew the Gawker Post was not coming down. TMZ, Stern, Sway. Look how he kept this in the news. I ask you, was this a work between Bubba and Hulk Hogan? Now, let's shift our focus a bit. Mr. Durkell talked about Professor Foley. And you'll recall that Professor Foley made certain judgments about things that he thought ought to be included in the newspaper. Some of those things he allowed us how other people objected to. But when he was in the editorial hot seat, he stood by his judgments. Remember his testimony about his defense of publishing that news article with the accompanying photo of Demi Moore, nude and very pregnant. Professor Foley was the first to admit that even though many readers disagreed with that choice, it was his right under the law. And Professor Foley admitted that different editors make different calls. For example, we talked about, you may recall this, we talked about the videos of these terrible beheadings of Americans by ISIS, right? And some outlets, including Fox News, believed that it was important for Americans to see the horror that we face with this terrorist organization. So in their editorial judgment, they included footage, and they put a warning to their readers so you don't come upon it unawares. Others made a different judgment. Other news outlets said, no, I'm not going to do that. Professor Foley, in our case, testified that no responsible news outlet would include this video, portions of this video, the Hulk Hogan sex tape, in its news broadcast. He retreated when we showed him a piece from the local ABC broadcast that did indeed include parts of this video. The station's decision, ABC's decision to include footage was an editorial choice that Professor Foley told you was over the line. But what else did he tell you? It was lawful. At the end of the day, Mr. Belea's own expert conceded that these are judgment calls, and different editors make different judgments. Now, the plaintiff wants you to think that Gawker knew that publishing the 41-second video was wrong and they did it anyway. The plaintiff presented no evidence of that. Mr. Denton, Mr. Delario, and Ms. Carmichael, all the people that were involved in the editorial process, all testified that they believed the video excerpts, as part of Mr. Delario's commentary, were indeed newsworthy. They all thought it was protected. When Mr. Belea's lawyer sent a letter to Gawker demanding it to take down the post, Gawker declined because it was protected speech. In fact, Gawker's lawyer explained that the existence and content of the video had been widely reported, and that the 1-minute clip shows very little sexual activity and is clearly newsworthy given the public interest in Mr. Belea's marriage, his divorce, and his extramarital activities. Members of the jury, that has been our position from the start. It remains our position today. It is the defenses that you have seen us put on in this case. And Mr. Denton, Mr. Delario, and Ms. Carmichael all testified they continue to believe in the video's newsworthiness as accompanying that commentary. Plaintiffs have presented no evidence that defendants believed this publication was unlawful, yet published it anyway. Plaintiffs want you to believe that Gawker had bad motives. Bad motives. These are bad people. You heard about that this morning. Bad people. Because of some virtual water cooler jokes, right? Making fun of this campfire thing. I don't get that. I don't have that in my office. But, you know, it's a new age. So they're on this campfire business, chatting with one another. And they do indeed make jokes about Hulk Hogan. But that's not malice. It doesn't show knowledge of wrongfulness. It may be inappropriate humor, may indeed, but we don't sue people in this country for that. More than that, step back. Think about what you've seen. Think about what you've seen in this case. The jokes that the Gawker staff were making were very little different than the ones that Hulk Hogan and his own lawyer made on TMZ. Very little different than the jokes that were made with Howard Stern. Do you remember that exchange where Howard Stern's going on and making these jokes about dropping the tripod and all this stuff? Same kind of humor. Same kind of humor. His lawyers come in this court and they point an accusing finger, at a joke about a tender leg drop, but they don't seem troubled when the very same jokes are made on Howard Stern. That's not malice. It's not malice. As Mr. Belea said himself, it's a joke. Yeah. Pardon me. As Judge Campbell told you, one of the plaintiff's claims is called invasion of privacy based on right of publicity. She told you this means that the plaintiff must show that Mr. Delario, Mr. Denton, and Gawker used his name or likeness for a commercial or advertising purpose other than the publication in which the image was used. Plaintiff claims that Gawker used Hulk Hogan's image to advertise itself, to promote its brand. He claims that Gawker used his image for commercial purpose by posting the video and then linking to that post through Facebook and Twitter, right? Think about that. The claim makes no sense for two reasons. First, writing a story and posting a video to accompany that story happens thousands of times a day on media websites throughout our country. Those websites send out countless tweets each day with links to their stories. Those websites post thousands of links on Facebook. You folks know that. But think about it. None of that gives rise to a claim. Every day you see articles, videos, tweets, and Facebook posts about celebrities and public figures. It simply cannot be the law of our land that every time a website runs a video of Donald Trump or Hillary Clinton and then posts a link on Facebook that Mr. Trump or Ms. Clinton could file suit, pursue a claim. It cannot be the law of our land that every time an entertainment website tweets out a photo of Kim Kardashian or posts a video on Facebook that Ms. Kardashian has a claim. That isn't the way it works. If the plaintiff were right, if posting a short, truthful video of him to accompany a commentary can be the basis for a claim, then the Internet as we know it will cease to exist. Second, Gawker did not benefit commercially. To try to prove Gawker derived a commercial benefit and to justify plaintiff's claim that he is entitled to, now we're told somewhere in the neighborhood of $50 million, right? $50 million in damages. He brings in two experts. First, he brings in Mr. Shun to tell you that the video was viewed millions of times on other websites. Mr. Shun admitted, he's an honest fellow, he admitted that he didn't know what the numbers reported by those sites meant, much less how many people actually saw the Hulk Hogan video excerpt on those sites. You heard him tell you that it would be pure speculation to say that anyone who watched the video excerpt would pay to see it. Ma'am, would you like a bottle of water? Okay. No. So he says to you folks, he says, well, yes, it would be pure speculation to say that anyone who watched the video excerpt would pay to see it. Well, where do we go with that? This morning you see now they want roughly $5 for all these people on these other sites. Yesterday we heard from an employee of MindGeek. I'm sure you're sitting there scratching your head going, who the heck is this guy, right? Well, that guy is with a Canadian company that runs a website called Pornhub, which, believe it or not, is the world's largest purveyor of pornography. He tells you, he says, well, people these days, you can watch celebrity sex tapes for free. And he told you that Vivid Celeb, the company that plaintiff says charges $5 to watch a sex tape, they post their celebrity sex tapes on Pornhub so that people can watch them for free. Since celebrity sex tapes are widely available for free on the Internet, plaintiff then brings in another witness, Mr. Anderson, who told you he was not aware of a single time when his method for valuing a company had been used in the real world. He told you he was not aware of any other instance where his method of valuing a single post had ever been used. He told you his method was based on a theory last used when the tech bubble that resulted in the dot-com crash of 2000. Now, his conclusion was not supported by the data that you saw. He says that the Hogan post increase the value of Gawker.com, just that one website, by anywhere from $5 to $15 million. But you saw the numbers for yourself. Gawker Media, the whole company, made $22 million in revenue in 2012. And as Scott Kidder, the CFO told you Gawker.com accounted for less than 10% of that revenue. Now, you saw that Mr. Anderson based his analysis on how many people came where? To the post, not the video. That number was far less. And you saw that the Hogan post was one of 10,000 posts on Gawker.com that year, and one of 100,000 posts on all, if you take the whole family of Gawker websites. So it accounts for only a tiny percentage of total page views. You also saw that there were bumps. Remember we talked about the traffic? There were indeed bumps in the traffic data. When Mr. Hogan appeared on the Howard Stern show, there was another bump when he publicized his lawsuit. But you saw that the traffic actually fell from October 2012 through April 2013. There was no sustained Hulk effect on the site's traffic. And you heard from Peter Horan. Mr. Horan is the media investor with years of experience running and investing in some of the country's largest websites. He did a detailed analysis to find out how much Gawker earned in revenue. He found that Gawker earned around $11,000, even if you give the plaintiff every benefit of every doubt. The Hogan post did not benefit Gawker's bottom line. There was no meaningful commercial benefit. In one of your questions, you asked Mr. Horan if posting the Hogan video somehow benefited Gawker's brand. And he told you, in his judgment, in his opinion, it did not. After he testified, we went back, we looked at the posts on Gawker.com's Facebook page. The posts about the Hogan story that plaintiff claims was the key to Gawker's viral marketing, his viral marketing strategy. Do not, at any point in this process, take my word for it. Check it out for yourselves. If you want to see that, look please at Plaintiff's Exhibit 63, pages 3 through 6. And what you will see those Facebook posts. Look at them. Assess them. And here's what you're going to see. These are 2 Facebook posts that link to the story. See how successful this viral marketing was. The first was shared 36 times. The second was shared just 17 times. So what is the actual evidence supporting plaintiff's viral marketing and brand awareness theory? 53 shares on Facebook. Less than a friend might have after posting a photo of her new puppy. Hulk Hogan was not the key to Gawker's brand identity. Although Gawker's websites might not be to everyone's taste, they may not be your cup of tea, but they were well known, all right? They had been around for 10 years, for a decade, which in this online publishing business is significant. So they've been in business before this Hogan post. You saw that Mr. Denton was interviewed on NBC by Brian Williams about Gawker's influence, and that was in March of 2012. He's getting interviewed on NBC well before it posted anything about Hulk Hogan. You heard from Mia Libby, head of Gawker's advertising. She told you that ads are sold months in advance, and they are not and cannot be sold in connection with a single story. If you think about that, that makes some sense. She told you also that the Hogan post was tagged not safe for work. You've heard time and time again what that means, so I'm not going to rehearse that again. She told you that these NSFW posts, they are not the kind of things that Gawker's blue chip advertisers like. They don't want to be associated with this stuff. It was the kind of post, as Libby said, makes my job harder. Now, you ask yourselves, well, I'm following along, but then why the heck do you do it? And she explained to you that it's like the separation between church and state. You've got the editorial people. What do they want? They want to put a story out there that people go, hey, look here, go look at that. The business people on the advertising side, what do they want? They want to run ads and have people shower them with dollars and get business, okay? But the two don't always go hand in hand. Far better to come out with some review of a new Apple product than some other sex tape story. But that has been true of the news business all the time. People in editorial want to put out good pieces, whether they be factual reporting or good commentary, good opinion pieces. And the folks in advertising are hoping to keep their jobs and be able to sell enough ads to stay in business. That is the news business. In TV, it's a matter of ratings, get you to the same spot. Okay, then I'll wrap up. Before I make my final remarks, I would like to ask you to do me one courtesy. We have now come to the only point in the trial where Mr. Belea's counsel has the final word. Under the rules of trial practice, he gets the last say because he has the burden of proof, so that's fair. That's how we've done it for a long, long time. There have been instances where Mr. Belea's counsel showed you or told you part of the story, and you may remember the instance where they played a piece of Mr. Denton's deposition, his video testimony, and then omitted the very next portion that explained his answer, so that we get to put that on. That's how it goes. We get that opportunity at trial to put on those omitted portions. Now, since we won't have that opportunity, we will look to you to keep a sharp eye out. The other thing I'd say to you is, and this is not criticism in any way of counsel, but there's been a lot of instances where a document has popped up and 3 words are highlighted or a line is highlighted on both sides, okay? Now, you folks, you get the opportunity, you get all the evidence, right? Trust your own recollection. Review the documents. See for yourself. Check us out. Not just plaintiff's counsel, check us all out and determine the truth of these matters for yourselves. You are the judges of the facts. So we're going to end where we began. Remember in voir dire I asked you about press issues, your views about the First Amendment, talked about privacy. So let's talk about the First Amendment. Let's talk about our common history, what we know from our civics class in days past. What do we know? What have we seen? We know that the First Amendment protects neo-Nazis who want to march in Skokie, Illinois. We know that the First Amendment protects a person's right to burn the American flag, no matter how abhorrent we may find that. Even pornography, even Bubba's radio show is protected by the First Amendment. Why? Why? You ask yourself, why is that? The reason The reason for that is because we don't need protection for popular speech, speech that everybody agrees with, all right? We need a First Amendment to protect speech that is controversial, speech that is offensive to many. What the plaintiff asks you to do here in this case, the plaintiff asks you to do is easy. To feel sympathy for Mr. Balea, to muster your dislike and your disdain for Gawker, to find that Mr. Valerio should have done this without the video. They're going to put you in the seat of judgment. They're going to put you in the editor's chair. But that was never how it was meant to work. What we ask you to do is hard. It's very hard, but ultimately it is right. We ask you to protect something that some among you may find unpopular. We ask you to put aside passion and prejudice and sympathy and follow the law. Law that has served our country well since our founding. Law that allows our citizens to write, to speak, to think about all topics, to hold public figures accountable as people who warrant the privileges we bestow upon them. I realize that this may be hard, but it is right in the long run for our freedoms. Shortly, we will come to the point where the voices of the attorneys will finally be still. After listening to all the witnesses and considering the evidence, your voices will be heard. We await your verdict, and I have to tell you, we appreciate your diligence and your attention. Thank you.